Why are we having this review? First, I would say that the most important part of the framework, and that is certainly the directive, is showing its age. I've recently mentioned we're approaching the end of consumption date. And that's true. It's likely to stay as is for a number of years, but we cannot afford to make this much longer. And part of the problem is also that we see now increasing diversity and complexity developing within the scope of the directive. That was the plan from the beginning, but of course all these national transpositions, which sometimes are contradictory at a horizontal perspective, are not helpful, and there is increasing complexity, and the challenges are increasing. So we need to scale up to the reality, global, increasingly technologically driven internet, etc. The second is the impact of the Lisbon Treaty. Now, this may be far from your reality, but it is a reality for all member states, and it is dynamizing the environment of the discussion. And one of the elements is the strong emphasis in the treaty on fundamental rights and the introduction of a new legal base for data protection has driven a more comprehensive, a more horizontal approach. So there is more now thinking, how should we do this well, and not only to make the internal market work better. And then there is an important driver in the digital agenda, already mentioned, and the longer perspective of the EU 2020 strategy, where the key words are smart, sustainable, and inclusive. And you understand the sentiments behind this. But we can never do this really smart, sustainable, and inclusive if we do not include data protection from the very beginning. And this is why it is such a critical success factor for many other policies which are building on this. So this is why we have this review, and this is quite obvious. This, in spite of the Swiss ban on slides, Chris, this text is important, and I have underlined some elements. This is Article 8 of the Charter, which is not part of the Lisbon Treaty, but there is one article making it binding nevertheless, the entire Charter. And it is the summary, the constitutional law on data protection for the European Union. So it states the right to protection of personal data. It sums up the key messages, and there is a strong emphasis on independent authority. You see that with a reference to the case, which explains what independence means. Now, the attention to the first line, because this is then echoed in the Treaty on the Functioning of the European Union. This is a new name for the EC Treaty. And in the EC Treaty, you find Article 16. That's quite prominent among the general principles of the Union, where this is translated into an obligation of Council and Parliament acting in the ordinary legislative procedure, which means the usual co-decision rules, qualified majorities in both houses, but co-deciding, to lay down rules relating to the protection of personal data by the Union institutions, but also by the member states when carrying out activities within the scope of Union law. Actually, this is now the legal base on which the review will be done. And it's not, I'll come back to that, it's not about making the internal market work better, but it is about data protection proper, rules on data protection. It doesn't say directive, it doesn't say a regulation, it simply says rules. And it is going to cover data protection at the European level, at the national level, within the scope of EU law. Of course, not everything. It could not be outside the scope of the treaty, but that is still a very big area. So I want to make you aware, and this will then have to deliver, in any case, what the Charter requires.